Okay, firstly, welcome everyone to this hearing. If a little bit of housekeeping to start with, if I could ask that everyone turns their mobile telephones off. Also, this hearing will be filmed, so if, therefore, by entering this chamber, you are consenting to be filmed and to the possible use of those images and sound recordings for broadcasting and or training purposes. As your images cannot be removed post-recording, if you are a member of the public and do not wish to have your image captured, you should sit in the public gallery at the rear of the chamber. If you have any queries regarding this, please speak to one of the council staff. We have no fire drills scheduled for this evening, therefore if the alarm does go off, if you could please exit where indicated. At this stage, I'd like the introductions of those present and inform all parties that the subcommittee will follow the hearing procedures, a copy of which was included in the notice packs sent to all parties. If we may now begin, if the applicant would like to introduce yourselves. Oh.
Yeah. Hello, Michael McGuire, Secretary of Sodley Bowling Club.
Matthew Butt, Counsel for the applicant.
Philip Hankin from Cole Jarman.
Simon McGrath, Dundonald Ward Councillor.
Anthony Fairclough, Dundonald Ward Councillor.
David Dean, Dundonald Ward Councillor.
I'm Elizabeth MacDonald, I'm a licensing officer.
I'm Daiva Bartki from Lower Downs Road, resident.
Edward Ash, Abbott Avenue, resident.
Duncan Siegel, Kingston Road resident.
Anne Fleming, Abbott Avenue resident.
My colleagues to introduce themselves.
Sorry, Guy Bishop, legal advisor to the subcommittee.
Amy Dimitrowski, Democratic Services.
Councillor Nick McLean will be chairing the hearing tonight. I'd now ask the legal advisor to inform those present that the subcommittee had a briefing prior to the hearing and to confirm the procedures and for clarification on any aspect of the application, and ask the legal advisor also to confirm that the process for questioning and whether there had been any requests for adjournment. I would also like the officer to confirm if there are any technical issues they feel should be brought to their attention.
So the committee have a pre-meet just to read through the papers and ask any questions that they want to ask. It's simple as that. They don't discuss it, the application, anything other than that. I don't think I've got anything else to say. There's no adjournments or anything like that.
Okay, on that note, I would ask the applicant to make their presentation, please.
Chair, as you'll see from the papers, this is an application for a club premises certificate for the Southie Bowling Club, 72 Lower Downs Road. As the committee will be aware, if this application is granted, the premises will have a club premises certificate and not a premises license. And that means the premises will be open only to members and their bona fide guests. The public will not be able to access the premises. And that applies every bit as much for someone who comes in on a Monday afternoon or an early Monday evening for a drink, as it does to someone who hires the premises, the ground floor or the first floor for a function. Only members can hire the function rooms, and only members can attend those functions. It's the critical distinction between a premises license and a club premises certificate that the members, in effect, own the equity in the alcohol that is sold, that the members have a much greater control over who is in the premises and who is not in the premises, and that as a result, there can, in appropriate circumstances, be a little more flexibility shown towards club premises than to premises licenses. All of that, though, of course, only if the grant of the application will promote the licensing objectives. The former clubhouse is still located, in effect, on the other side of the site. There has been a physical club and a club with a license on the site since the early 1950s, and the club itself was founded sometime before that in 1886. This is a club with a very significant history in the area. All of the members of the club are local. Everyone either walks to the premises or gets a bus, and some people drive, and there's a car park on site. The average age of members is somewhere around about 60, with members up to their 90s, and I think the youngest member, and those are very much in the minority, is in mid-20s. It would be very sad indeed, in my submission, if that over 100-year history of the club were to come to an end today. And I very much hope that the subcommittee will be able to find a way through a committee-led discussion to ensure that is not the case. As members may well have gleaned from their local knowledge and from reading the papers, there has been a major redevelopment on the site. The existing clubhouse is going to be demolished, and a significant residential building program has begun and is continuing. Part of that involves the construction, and this is finished, of a new clubhouse that's going to replace the rather tired facility the club has been using since the 1960s. And reading in between the lines, it perhaps is not too hard to notice that there has been an acrimonious planning process in relation to that much wider development, and that perhaps there is some lingering unhappiness as a result of that. And of course, as the committee will be well aware, those broader planning issues play no part whatsoever in today's determination. In introducing the application, I'd like to deal quite briefly with the following matters. The hours that are sought for the certificate, and I'm going to explain how the hours we in fact are seeking are going to be cut back from the application as originally made. An explanation of the nature of the premises and what we intend to do at the premises. The question of planning, public nuisance, crime and disorder. I'd also like to propose some conditions which hopefully will assuage any concerns that either those councillors representing the residents or the councillors on the committee will have today. Can I deal first, therefore, with hours? As the committee know, the application was originally for alcohol and regulated entertainment until 11 p.m. Monday to Thursday, 23:30 on a Friday, midnight on a Saturday, and 10:30 on a Sunday, with supply of alcohol to 23:30 Sunday to Thursday, midnight Friday, and 1 a.m. on Saturday. What I'd like to do to make this very simple and straightforward is this. We would ask the committee to grant only alcohol on a Saturday until midnight, and we would ask for live and recorded music to cease at 11:30 on a Friday and a Saturday. So a terminal hour of midnight on a Saturday, and on a Friday and a Saturday, live and recorded music to cease at 11:30. This would amount to a very modest extension from the existing license, and of course I appreciate that there's no such thing as a transfer in this regard, but a very modest extension of 1 hour for alcohol and 30 minutes for regulated entertainments at weekends only. This would be well within the, in effect, framework hours set out in the current and the draft licensing policy, as in fact with the application as originally made, but as amended, it is significantly less than the framework hours, even where those hours recognise premises that are adjacent to residential properties. In effect, in exchange for this, so in exchange for granting a new certificate with very slightly longer hours at the weekend. The residents will benefit from not just a premises that is purpose-built with far, far superior noise insulation, but also a series of enforceable conditions that can ensure that if there are problems at the premises, those can swiftly be dealt with. Now, can I acknowledge at the outset that even with those amended hours, what we are requesting is slightly longer than those hours within our current planning consent. It's a matter which a number of residents and the councils representing them quite rightly make in their representations. What is the significance of that? Well, the first thing to acknowledge at the outset is, of course, that premises can only trade until the hours in its planning or its licensing, whichever ends sooner. In terms of your job today, I can really do no more than to refer you to the statement of licensing policy, which remains as it currently is, both in the in the current and the proposed draft. 2.1, the licensing authority believes it's good practice to ensure the necessary planning permissions are in place before a license application is made. However, it's recognised that planning and licensing legislation have differing objectives and must be decided separately. The consideration by a licensing subcommittee will not be a rerun of the consideration of the planning application.
But, my friend, we've had the legal advice on that already, so if you
Yes.
wanted to move along, that's fine.
Right,
We're
very
well
grateful.
aware of...
In essence, it's a separate consideration. It's not relevant today. I can no more say you must grant us hours consistent with our planning than anyone else can say you must not grant hours in excess. I'm very grateful. So this must be considered on the merits. In terms of public nuisance, I accept that there are representations which, in varying degrees, say that there have been problems on the existing site. There are also, however, residents who take what is perhaps a more realistic, the committee might think, approach to the existing operation, and the councillors will be painfully aware of the fact that there is no representation for environmental health, none from the police, and no history of enforcement against these premises. At page 91 of the agenda, a resident who may or may not be here today, I don't know, says this: as one of the closest neighbours to the current bowling clubhouse, we have always found them to be good neighbours. Parties were infrequent and ended at a reasonable hour. And of course, I note that representation does then go on to say that the 1 a.m. application would, in her view, change all of that. Well, I hope the reduced hours that I've outlined already would be of some comfort. I know a resident who is here today, I think Mr. Ash, has submitted an additional representation, which was originally a video, but there is metadata which you would have seen, which shows that the premises were open and that there was a function at a little past 11:30. I think it was 23:39. It is correct. That is in breach of the existing club premises certificate. I've spoken to the applicant about that. It was an 80th birthday party. It should have finished, of course it should have, on time. It didn't, and the applicant apologises for that. It may well be the case that premises who have traded for a long time without a history of enforcement action can sometimes become overconfident. There must be no repeat whatsoever of that, and the applicant assures the subcommittee there will be no repeat of that. As I say, it was an 80th birthday party, and it occurred a little after the permitted terminal hour. In terms of additional conditions that can be imposed to the certificate, I've really tried to distill all of the concerns raised in the various representations and propose conditions that can deal with all of them, or I hope will deal with all of them, and I can provide them in writing if that's convenient, shortly before or shortly after the subcommittee retire.
You want to hand it up now so they can have a look?
I can't do that because I haven't actually done it yet, but I will do that before the end. All right, but they're pretty standard. I don't think they'll come as a surprise to anyone. So first of all, can I propose a condition for a noise limiting device? So something along the lines of all amplified regulated entertainment to be controlled by an acoustic noise limiting device, the limit of which is to be set by agreement with environmental health. the applicant is very happy to offer that. The subcommittee will have seen a report from our noise consultant, which really certifies these premises can trade without causing a nuisance to the neighbours, but very fairly the consultant recognises in order to guarantee that a limiting device is required.
I mean, obviously that report's up to 11 p.m. But
Yes, well, I'll come to that. Yes, all right, thank you. Secondly, can I propose a condition which really closes all outdoors areas, including the balcony, after 11 p.m. So no drinks to be taken outside after 11 p.m. and the balcony area is to be cleared of members and guests by 9 p.m. Of course. So no drinks to be taken outside after 9 p.m. and just for the avoidance of doubt, additionally a condition that the balcony area is to be cleared of members and guests by 9 p.m. It's debatable whether this actually is a condition which I'm about to offer, which bites with the licensing objectives, but a number of residents have expressed concern about being overlooked by the premises, and in particular being overlooked by the function room. I've discussed that with the applicant. He is happy to propose this condition as well to the committee at all times that regulated entertainment is taking place. The blinds to the windows on the first floor are to be lowered after 9 p.m. It has to be expressed in that way because it would be absurd if the premises were shut and someone had to come in to lower the blinds. And the real concern, as I can see it from local residents, is there could be a function on in the premises and people would look in or they could see in. So if the blinds are lowered after 9 p.m., it is not ideal for the premises, but they see and recognise concerns raised by local residents and are happy to offer that condition, even if it might not strictly really bite in relation to licensable activity. Because we are a club premises and have that greater degree of control over members, I can also offer a condition concerning smokers. It hasn't been raised very much in representations, but it's always a problem on premises where alcohol is served. No more than 6 smokers to be outside after 9 p.m. As I say, I'm sorry to sort of throw these at the subcommittee. I will write these up and provide them. But really what we are seeking to do, as you can see, is to really cut down the degree of light pollution, noise pollution, and people who are in areas that are noise sensitive after 9 p.m. We would, of course, be agreeable to other conditions that reflect existing procedures, such as signage asking members to leave quietly, phone numbers to be available, and a dispersal policy to be drawn up. But the conditions I've offered already really are the harder conditions that are likely to bite and to ensure that there are no problems at these premises. So, Chair, as I say, no representation for environmental health. A number of residents express concern about crime and disorder. I don't think anyone is realistically saying that they think bowling club members are going to commit, for example, burglaries or anything like that. I think the concern is the development of the site might indirectly in some way lead to people coming in and committing offences, and distressingly, of course, we'll all have noted that there has been a burglary very local to the site, I think, over the course of the development. All I can say in relation to that is these premises have never been visited by the police, apart from socially some officers are members and come to the premises. But actually, the new facility is going to be much better in terms of crime and disorder. The CCTV coverage is much better. The lighting is much better. The site is going to be much more secure. There is an access path that runs in between the new clubhouse and the residential properties on Lower Downs Road. And I think some residents expressed concern about that. We really are going way beyond licensing. I discussed it with the applicant. He's happy to, and has discussed this with residents and councillors, put gates at either end of that and make the access codes available. But I would ask that not be conditioned, because it's the sort of thing that can have more complexities if it's conditioned than it can by way of flexibility. But I raise that just to say that, in fact, this refurbishment is going to be of benefit to crime and disorder. And in terms of the licensing objectives, will this club premises certificate of itself bring crime and disorder? Well, it really won't. The police, as you know from the statutory guidance, are the experts on crime and disorder, and they have made no representations in relation to the application. The premises, there's one other condition I should have mentioned before, I'm so sorry, and it's this. Doors and windows to be closed after 9 p.m. when regulated entertainment takes place, aside from access egress. There is a double door in the ground floor entrance, unlike in the existing clubhouse where if you open the door, then you're exposing the noise inside to outside. It is lobbied, so access and egress can take place without problems. This is the sort of community-focused project that in our submission ought to be encouraged. The members are local. It would be a tragedy if the over 100-year history came to an end tonight, and we are prepared to work with, of course, the subcommittee and the local residents' concerns they've raised in order to ensure that we can continue to exist without causing any concern to local residents, and we can answer any questions the committee might have. Thank you very much.
At this stage, we're going to ask the interested parties to question the applicant. However, I would make the comment, I know the council did this before, we would like questions and not statements, and if we can keep them quite brief.
Who is the designated licence holder? Or who is the designated licence holder?
It doesn't have one. It's a club premises certificate. There's no DPS because it's not a premises licence.
Who was in charge on the night when you had a video recording of music and alcohol being served after your licence?
I suspect Councillor Dean knows the answer to that question if he's seen the video.
I'm here to ask questions, not answer them.
Well, Mr. McGrath was responsible.
If Councillor Fairclough?
So sorry, I just need to follow up on that. Bearing in mind we had a licensing committee 1 week later, what's Mr. McGrath's opinion on why licensing was flouted on that particular night? If your answer, or maybe he'll answer too, but specifically, although I don't recognise the difference between the licence holding, specifically, does he understand the rules of holding a clubhouse licence? And can you give me his opinion on why that happened on the night?
I think I've answered that already. I've apologised on behalf of my client. I've assured, if you could let me finish, please. I've assured the subcommittee it won't happen again, and I've explained it was an 80th birthday party and that there can occasionally be complacency where premises have had certificates for a long time without formal enforcement history.
Councillor Fairclough?
Thank you very much. Coming back to possible issues of complacency, as you mentioned, in the application on page 25, the applicant must set out how they intend to promote the 4 licensing objectives. And rules 13 and 14 of the club's rules are referred to. And I wondered if the applicant could set out precisely how those rules will in fact ensure that the 4 licensing objectives are met.
I've offered the additional conditions because I can see that the committee will want to have more than simply the rules of the club in order to ensure the objectives are promoted. So I take your point.
Thank you. Just for the panel's benefit, my point is such that the club is not necessarily in a place to ensure that licensing objectives are met in its current plan.
If I could respond to that, of course, the committee can grant the certificate with conditions that are either set out in the club operating schedule or offered at the meeting. And my hope and expectation is that the conditions we've offered with the revised hours will meet those objectives.
Councillor McGrath?
Got several questions. Shall I ask them both at once or? Fine. My first question is, on the 18th of October, there was a planning decision on the new air conditioning units. There was a substantial discussion at that planning committee about the noise levels of the air conditioning units and an agreement that the air conditioning units would switch off a certain amount of time after the end of the events. And at that meeting, there was no discussion about changing the planning hours. They were exactly as approved originally. What has changed? First question is, what has changed between the 18th of October and when you submitted this application to mean that you now need longer hours? My second question is, a number of the conditions that you have offered up are already in the planning condition. For example, other than for purposes of maintenance and in the case of an emergency, the bowling clubhouse balcony shall not be used between the hours of 2100 and 1100 Monday to Sunday. So you're offering up to the committee something that is already in the planning commission condition rules. It also includes, and I haven't found this, but in your own noise assessment report, it also includes a noise limiter in the planning committee. So you're not offering anything new, you're just admitting to the planning conditions that you've already agreed to.
Do you have a question?
Yes. So can you explain why you haven't, what is it you're offering that's new? Third question is, you've spoken at some length about the future of the club, as if this licence application, if it doesn't go through, the club won't have a future. Could you explain why you're saying that? And thirdly, on the noise assessment report, fourthly, in fact, a question. In the noise assessment report, you referred to a number of criteria set down by the Institute of Acoustics, and you've chosen criteria A22, which I won't go into all the details, but basically is where it ends by 2300. But in your application originally, you were going on much longer than that, so I don't understand what evidential value this has when you're originally applying for a much longer time period. Thank you.
Thank you.
I would have answered a lot of those questions in the application because virtually all of them relate to planning. But I didn't because, quite rightly, I was told planning is not relevant. But in the interests of the residents who are represented, let me just broadly address them. It is very common in licensing to offer conditions which might well duplicate planning conditions. The main reason for that is that enforcement of the license is much easier than enforcement of the planning condition. It is a criminal offence of itself to carry on licensed activity without a license, but it's not quite so straightforward in relation to planning. So it's rarely an answer for an applicant to say, you don't need to put anything on the license because all these matters are dealt with by planning. First of all, because that breaches the injunction not to cross-pollinate between the two areas. And secondly, because everyone knows licensing enforcement is much easier, much quicker. And frankly, certificate holders and premises holders are much more scared of licensing enforcement than they are in relation to planning. So that's why we're offering up those conditions. A sneaky applicant would try and get away with just saying, well, we don't need to do that because they're all on our planning permission. But we thought it better to be open and honest with the committee in relation to that. In terms of, entirely right, yes, the noise report is based upon entertainment ending at 11 p.m. And we are asking for 11:30 p.m. on a Saturday. So to that very limited extent, the applications is now made is a little longer than that. It's a matter of the subcommittee whether they think that given what we've said and the conditions we've offered, this can be granted and that would not harm the licensing objectives. In relation to the air conditioning units, I think that is trespassing directly into planning issues. We intend to vary our planning consent in relation to hours if this committee grants a modest extension. If it doesn't, we won't have to. If it does and we don't manage to change our planning, well, we won't be able to trade until the later hours. If these premises don't have a club premises certificate, then they simply cease to exist in the manner in which they have since the 60s. It would not be the bowling club it was. If it doesn't have a license, it can't offer the facilities it traditionally always had to its members. It would take away the lifeblood of the club.
Councillor Dean.
Specifically on that question, you've talked about the club will end today. The current licence, may I discuss the current licence, is less hours on this. Are you saying that they would cease to exist today based on the current licence?
I think it's important to understand what's happening here, and it might be that Councillor Dean and maybe others haven't quite grasped it. I don't mean that in a patronising way at all, but it's very important because this is why this decision is very important. You can't transfer a certificate from one premises to another. The current clubhouse is going to be demolished. That is all finished. The planning decision over and done with. So that will not exist. So if nothing is granted for the new premises, there is no certificate. There's never been a license. It will come to an end.
That's not the issue.
Yeah, Councillor Dean was referring to the fact that if the new building, I suppose it's a bit of a hindsight question, if the new building hadn't been built and you were still trading under the existing club licence on the existing spot, that the property, that the bowling club would cease to exist.
No, the problem here is that you've got the specific old club, the one floor premises, whatever you want to call it, shed, I don't know what, club, or whatever, and you've got the new site. They are distinct. The change is substantial, and as a result, the old club premises certificate will lapse when the building goes, effectively. So they have to have a licence in the future for the site that they're now building.
Everyone knows that. The point is, if there is to be one licence on this plot, the current licence is different from this licence. So we're not here to say we disagree that there should be a licence. What we're saying to you is that you're specifically saying, and these were yours, that the club will end today if you don't get what you need. So my question is, but at the moment you have a licence, but you're still surviving. So why is the difference? If you can answer the question rather than not.
I am honestly trying to answer the question, but first of all, there's no licence. And it's really important we don't mix up licenses and certificates. There is a certificate. It is linked to the old building. That building will be knocked down. So if the committee were to refuse the application today, that building will be knocked down and there would be no club premises certificate that could be used by Southey Bowling Club. I don't know if everyone has appreciated that.
If there's only one licence, Chair, are they ever allowed to apply again?
Yeah, but, yes, but when an application
You've got a committee that's made a decision to refuse the certificate.
Councillor McGrath, and then we'll open up to any of the other interested parties who would like to ask questions.
I'm sorry to press on this point. If the committee gave you a licence with exactly the same hours as the licence on the old clubhouse, which I'm assuming is something that the committee could do, does that pose any risk to the future of the club?
Right. That is the question Councillor Dean was referring to. What I was saying is that the application is refused today. I'm not here trying to hold a gun to someone's head or to tell people you must do what we ask, otherwise we can't trade. It would have a massive impact on the premises. I don't have instructions as to whether we could survive or not. And I certainly am not saying, and have never said, unless you give me exactly what I want, the club will close. I was talking about a scenario in which nothing is granted at all.
Any other interested parties that would like to ask a question of the applicant? Okay.
So I'm Daiva Bartki from Lower Downs Road. So my house backs onto the bowling green, and I've been living there for 4.5 years. So I saw how it was before construction and now. So to pick up from your introduction, you said that public will only be able to access the function. Public will not be able to access the function. Only members will. Can anyone become a member?
It's a mandatory condition of a club premises certificate that there must be a gap in time of days in between application and membership. In short, no. The whole part of club premises certificate is to make sure that people who are members genuinely are members. They own equity in the premises. There is no prospect of a genuine certificate being abused in that way. It would be outrageous and a breach of the law if that happened, and there's no suggestion that Southey Bowling Club have ever done that. So I can entirely reassure you there is no opportunity with a club premise certificate for someone just to turn up and say, well, can I join today, or can I join tomorrow, and then have a party there.
Just to add to that, there's a period. There are various conditions in the Licensing Act for club premises certificates, which require those going in who are trying to become members 2 days before they become members, and also use. If they're going to become members, they've got to do it 2 days after they've been made a member. But obviously, there's a process of being seconded and proposed to become a member anyway.
Okay, thank you. So next question would be, what's the current capacity of the clubhouse?
Current capacity is 100, as in the existing
Yeah.
premises.
Yes.
There is no capacity on the new building. It's somewhere in the region of 150 or 160 is the realistic capacity of the premises.
Okay.
And again, to add to that, sorry about this, there are, this is not, the capacities are not an issue that the licensing subcommittee deal with. They are dealt with under fire regulation by way of risk assessment, which are dealt with through the fire brigade.
So say it's not an issue, the amount of people, but the new application mentions 160 people. So what sort of, and you talked about noise limiting device to be present. How do you assure that when those people leave at different times in the day, do you have some sort of noise limiting device outside to absorb all that noise when the door is open and shut over 3-4 hours, if it's until midnight?
Yeah, so the noise limiting device and the noise report has 3 different noise measurements. It has the sort of effectively the equalized noise measurement, and also one that takes account of sudden loud noises. So it would measure both the sudden peaks, and also it would measure the background average noise. And the noise limits are agreed in consultation with environmental health in order to ensure a suitable level is agreed that doesn't cause a nuisance on any of those bases. Also, the premises had the benefit, the new premises do, of a lobby. So you walk into an initial set of doors, that door shuts, then you go through the next doors, and that significantly reduces noise breakout, as does, of course, the fact that the first floor function room will be much better at containing noise, certainly than the existing premises, and certainly than anywhere that was either ground floor or ground floor without a lobby.
So the next question is, you mentioned that no drinks had to be taken outside after 9 p.m. How can you police that?
It's a pretty standard condition on club premises certificates and on premises licenses. The advantage with club premises is there's much better control and supervision of members. They'll all be known to the club secretary. The premises are well staffed. There are marshals at events such as this. We're very confident we can ultimately. If we can't, it's our problem. We commit a criminal offence and the certificate can be revoked. But nobody would offer conditions like this unless they were confident they could comply with them.
And again, to help everybody, the ultimate sanction for a club premises certificate holder would be for membership to be taken away from that person who's breached the condition.
Okay. The next one, I haven't got loads, but a few more, please. Bear with me.
We'd like to bring other people in as well. So
Yes, only a few left. So when the bowling greens games are happening, they normally finish at 9 p.m. If the balcony is not to be used after 9 p.m., why did you build it in the first place? You notice that nobody can use the balcony on the first floor after 9 p.m. The people are normally downstairs playing the game before 9 p.m. Why did you build it there at all?
This isn't going to be the answer you want, and so they can use it before 9 p.m. I'm sorry.
The members, sir? Well,
Some people might want to watch from upstairs.
I'd like to move on to other interested parties now. Sir?
You state that the balcony doors, French doors, which take up most of the fascia of the first floor, will be closed. How do you propose to ensure that?
It's very easy to ensure that. It's the same answer as to drinks outside after 9 p.m. It's the responsibility of the committee and of the staff in the premises to make sure it happens. If they don't do that, they commit a criminal offence and they put the certificate in jeopardy.
But it's a door. Somebody will open it. Are you planning on having somebody standing by the doors throughout an event and preventing them from going out?
Yes, we will supervise the first floor to make sure that guests and members don't open them. Some of them can also be locked, subject to fire regulations. But again, it is perfectly standard. The vast majority of premises which have conditions, which have regulated entertainment, will have conditions that doors and windows are to be shut during such entertainment, save for access egress. It's an easy condition to comply with.
If I may ask another question, in the noise assessment report, it says the capacity of the club is 160. Is that correct? Is the noise assessment report correct?
As has already been indicated, ultimately the noise capacity will be set by fire and emergency planning. We anticipate 160 will be the level, yes, the capacity.
Can I ask you, how quickly do you think it will take to clear 160 people from a party in a noiseless way?
There would virtually never be 160 people at a party, and certainly there would never be 160 people leaving the party at the same time. We have already drafted and will agree a condition in relation to a dispersal policy, ensuring that customers leave the premises in a quiet way. We have signage reminding customers to do that. We have the benefit of a car park where taxis can come and pick customers up from.
One last one. In the noise assessment report, it says the club will be available for outside hire. Is the noise assessment report correct?
I haven't got that precise part of it to hand at the moment. If by that the author meant that somebody who is not a member of the club can hire it, then I'm afraid that is inaccurate and wrong. It cannot be hired by people who are not members. No club premises certificate could offer that facility. We'd need a premises license for that, and we haven't applied for one.
I have a couple of questions. Imran Kali, Abbott Avenue.
If you could just introduce yourself as well.
Yeah, Imran Kali, Abbott Avenue. The question I have is in relation to the legal advisors of the applicants on crime and disorder, where he makes a reference to an access path, which is, there's a proposition to put some gates up, as I understand, to limit access. But my understanding is that these access paths aren't for the club's use. In fact, they're owned and to be only be occupied by the residents of Lower Downs Road and Abbott Avenue and Kingston Road. So my understanding is that the club users and the club members have never had legal access to it. They've just casually been allowed to do so. So I see an issue there with putting gates up, but I'd like to hear your comments on that.
And that is precisely why I said, please don't put that as a condition, because there may well be concerns exactly such as that. If that is something the residents want us to do and we can reach agreement, we will. If they don't want us to do that and we can't reach agreement, we certainly won't. And that was why I did say, please don't condition it, because people may have differing views.
Okay, well, it's probably something that you won't be able to achieve given that you don't own the land, so that might be an issue. My next point would be in regard to public nuisance again, and many people have sort of reflected upon what they've put in their various rejections or applications to reject your application. But you state here today that individual members will only be able to hire the vicinity, and those individual members will be able to hire the vicinity for events. And then those events, would those individuals that attend that event, will each and every member attend, or will it be members' guests? And in fact, those guests will not be members, will they?
So you would have to have booked by a member. You would then have to have members attending or bona fide guests of members. But this is something which the law has recognised for a very, very long time. And as you can imagine, premises have tried to get around having a premises licence by claiming they're a club and trying all the dodges like this. So someone joins the same day, someone's a member but signs in large numbers. But people, you can't do it. It is a club for the members. The members own the equity in it. There's no point doing this unless you run it for the members. You can't make a profit.
But to reiterate my point, members, guests will be able to attend who aren't actually members. Those guests in themselves, right?
Yes, you can have bona fide guests of members, but the members remain responsible for the behaviour of their guests. The effect of it is that you have virtually all members and a very small number on occasions of guests of members. But it can't be used as some kind of a device to allow it to be, in effect, hired by the public or full of the public, but with only a handful of members.
Well, you'd only need to know a member and you'd be able to hire it, right? Because that member could hire it for you.
No, that's wrong.
I think that could happen, and it does happen.
It doesn't happen, and it couldn't
I'm
happen.
fairly confident.
Mr. Butts answered the question.
Well, he knows what he's answering.
At this stage, I'd like to open up. Oh, we have one more from the Interest Party, then we'll open up to the committee.
One more, please. My name's Stephanie Nalon. I live on Kingston Road. I'm satisfied with the explanation of premises license that currently exists for the bowling club address at Kingston Road. My question is regarding the new license, which may or may not be granted to 72 Lower Downs.
First of all, it's a certificate.
A certificate, I do apologise, the certificate. Noting that you've taken into account the robust objections from the neighbourhood, why seek the extra half hour?
The original certificate was granted in the 60s, and it was then transferred under the 1964 Act and then transferred again under the 2003 Act at a time in which the law was you pretty much had to have specific hours set down by Parliament, which were set really based on wartime considerations. When the 2003 Act came in, the idea of hours restricted to 10:30 on a Sunday and 11 o'clock during the week went out of the window. And in fact, the London Borough of Merton has a policy which sets out guideline hours which are far in excess of the hours that we applied for, and much, much far in excess of the hours that we are requesting. We're simply asking for a little flexibility on weekends in order to enable members who want to use facilities to use them. We don't think that an extra half hour for entertainment and an extra hour for alcohol on the weekend is unreasonable, but of course that is a matter for the councillors, and I can't say any more than that, and I'm sorry if you'd rather we didn't. I genuinely mean that.
Thank you for your answer. I appreciate it.
Okay, we'll open up the questions now from the committee, and I'll go first here. A number of the interested parties have made reference to the operational aspects of the bowling club. Clearly there is going to be an increase in numbers. So I'd like to hear from Mr. McGrath exactly how you operate the bowling club at the moment. We've mentioned keeping, or one of the conditions, 6 smokers after a certain time. How is that going to be policed? And if we could just run through and let me know, I'd like to know what bar staff you have, security, the whole works.
So we're going to make it mandatory that if we have a function in the club, there'll be at least 2 committee members on duty to police it at all times. The bar staff, obviously we've got bar staff that operate the bar and staffed accordingly, and we've also got the chairman of the house and bar, which monitors the evening, etc. As regards to the operation of the club, primarily the club is opened for bowling from April to September. Predominantly, you get maybe 1 or 2 members down during the week practicing on the green, and some matches in the evenings, which automatically, due to light constraints, finish at 9 o'clock anyway. The whole idea of the opportunity to the balcony is so people from the higher position can see the green better. No other reason other than that. It's just make it for people to be able to see the green better.
We would like to think potential 160 people, 2 members. How will you scale up? How will you? There must be there's increased capacity here. When you refer to 2 members, is that what you operate at the moment with the previous premises, or are you going to be scaling up with the new premises? What are the plans?
So explain, if you had a big function with 100 or 150 people, how many staff there would be on duty and what they'd do?
Yeah. So if you're primarily the functions we see in the club going forward, if we exceed 100 members in the club at any one time, I would be frankly amazed. If there is to handle bigger functions, we would staff it accordingly and say instead of having 2 committee members policing it, we'd up it to 4. And that would be separate to bar staff. The bar staff are not committee members or officers of the club. They're paid members, are paid staff.
Thank you. How well is the club used?
By members, effectively, it's well supported during the summer months. I get the 60-odd bowlers congregated on the area, and basically they have the matches and they disappear. It's used socially by, on average, between 10 or 20 people per evening. We effectively get the odd function that we arrange, and basically that caters for the quieter months, so it keeps the revenue in check.
Are you anticipating to have a lot more functions by members?
We would like to see an increase in members. We would like the local community to make use of the facilities, primarily for, say, the likes of coffee morning, exercise classes, so on and so forth, and use it as a meeting point. We're more anxious to promote it in that way, rather than have the opportunity of depending on parties. I'd say, on average, if we achieve 12 parties or functions a year, that would be about it.
Okay, so you want to add the community into making sure that they use the facilities. Will you be renting spaces to the community, like, you know, exercise or keep fit or toddlers groups or stuff like that?
We would look for the people from the surrounding area to become members of the club, and basically use it as a community-focused area as opposed to...
So the question was, would you hire the facility out for exercise classes or things like that? Do you do that at the moment? Do you have any concrete plans to do that in the future?
We've no concrete plans to do that going forward, but it's something we're investigating, provided it meets the limitations of our certificate at the moment.
Thank you.
Yes, I noticed you said that you'll have 2 club members surveying the situation. Will they be outside or inside doing this? And do you plan of employing any outside staff to control the whole area?
Bearing in mind that basically all the functions that are held in the club, everybody knows everybody. And if, for example, it's a nephew or niece or something like that, they're predominantly known. And what we find is basically if we police it with an area that we know the people are involved, they're more likely to comply, because we've got strict policy that if people do not comply within and behave properly in the club, they're automatically expelled.
The question is also, will you monitor the outside areas, I think?
Yes, absolutely. We will patrol the outside areas as well.
But will 2 members be able to do that if you got other people from outside come trying to get into the club?
So for anybody to be able to enter the new club, it's a secure access. They will not even be able to get to the door, and basically they will need to be invited and basically on the guest list. If they're not on the guest list, they will not be allowed on the premises, or a paid-up member of the club.
I'd like to go to page 89 of the supplement, or the main body of the report, actually. And you refer in a post that you made to 2 levels were introduced to separate parties from regular club users. Do you just want to explain that out? Is that your definition of parties versus regular club users?
You can imagine a situation in which someone, for example, a member books out the first floor for a funeral or a reception after a funeral. That wouldn't mean that other club members couldn't go in that day. It may be that the first floor want exclusivity. Say you had the funeral on the first floor and then regular members come in on the ground floor.
Because that appeared to get quite close to a premises situation. Interested parties, we obviously have a number, so if we could keep them very short, please, councillors.
Thank you, Chair. Tonight I'm representing my own evidence, but also that of 3 residents as well. So my evidence begins on page 53 of the main pack, that of Sarah Blackburn on page 68, David Cox on page 78, and that of Stephanie Siegel on page 119. What I hope to set out to the panel is that this is a quiet family area at the moment, and what I would like to do is to show the panel and to emphasise to the panel how close the new building is to the residential properties, and essentially highlight the existing disruption that the operation of the club causes.
So just to highlight, I did actually visit the site yesterday. I walked around it, the construction things, so I understand exactly.
Thank you. As I say, to emphasise that the existing operation of the club causes some discomfort to residents on its current hours, but to highlight how this change in the club certificate will actually take those problems later into the night and actually cause further and greater problems that are not promoting the 4 licensing objectives of the authority. My question highlighted, and I think a number of the interested parties commented, have highlighted the club's preparation and organisation for the problems that may be caused by greater use. And I hope the panel might agree that that seems somewhat lacking. I don't think any resident is trying to stop the club from operating. We're just trying not to make the operation of the club cause greater disruption. So I'd like to highlight, I know Councillor McLean has visited the premises, but I'd like to point to the photographs on page 70 and 71 of the main pack, which emphasise just how close the new building is, which is actually on a different side to the existing premises, how much closer it is to residential properties. I'd like to highlight the photographs at page 82, which show the lights at night operating in the new building. And on the very last page of the additional evidence, page 54, that shows the alleyway between residential properties and the new building. And I think all this highlights just how close the club is to residents and their everyday lives. So you've seen from the pack the descriptions of disruption. Now it's been pointed out that complaints haven't been made to environmental health or to the police. That's not, there have been some complaints over the years. But I also think it shows that the residents are quite happy to allow the club to operate. They're just very concerned about further disruption. And even to midnight or 1 o'clock in the morning, I think noise that might be acceptable from people, up to 160 people, in fact, leaving the premises at that time of night cause a greater disruption to a much smaller number of people leaving at 10:30 or 11. I wanted to come back briefly on that's the sort of public nuisance point, but I wanted to come back briefly on the crime and disorder and safety points. It's more that more regular use of people of the alleyways up and down the back gardens of properties makes it harder to spot suspicious behaviour. If it's much more common that people are walking up and down, whether drunk after the club has closed for the night or just generally, it makes it more difficult. And as anybody who looks at the local crime statistics knows, most burglaries take place through back gardens, not at all saying that club users will do that, just that suspicious activity is far more difficult to spot. Lastly, the residents that I'm representing tonight go out into some detail on the planning conditions, and I know there can be no cross-pollination, but I think the relevance here for the panel is actually that they highlight that problems were spotted by that committee and conditions were put in place to stop those problems that I think panel members, on the basis of the evidence of tonight, can see still exists. And so I hope the panel bears that in mind when it's considering the hours of operation and the music, the live music and the recorded music. And I think, to keep my comments very, very short, that's the main point. The balcony being a particular issue overlooking. This is a completely different type of building, much closer to residential properties. The existing building already causes a certain amount of disruption. Later hours, different building. We ask that the panel consider that when they make their decision. Thank you.
Mr. Butt, would you like to question the interested party, or would you like to go around to just pile on through?
No, thank you very much. No questions. Thank you.
Thank you. I've got two grounds for which I would ask you to, if you do grant a licence, to do them on the existing hours of the previous licence. And the first one is that I don't believe that the club has been particularly acting in good faith. They've put in a planning application with one set of timings, which quite clearly they were always proposing to change. They have offered you various concessions, some of which were already in the planning permission, which they already had to do, so they're not concessions at all. They've produced you an acoustic report based on an incorrect assumptions about opening hours, and which doesn't also mention the sound coming late at night from up to 160 people leaving down a small alley. So I think that's one ground that the club haven't been acting in good faith. The second ground, I think, comes back to the point that the representative of the club has made several times, talking about a slight increase in hours and a modest increase in hours. Now, if this was an increase in hours at 3 o'clock in the afternoon, it's very different from an increase in hours at 11:30 at night. And as we all know, if you have a child that can't go to sleep because of noise, half an hour or an hour is a very long time indeed. So I don't think that these increases are either slight or modest. I think they're quite considerable increases given at the time of night that they're happening, which is why I would ask you to keep the existing hours that the club has in its licence.
I'll try not to go over what the other speakers have done, so this will be from a slightly different angle. The Southey Bowling Club didn't start here. They morphed into another bowling club, but they've been around for 133 years and very successful. And I've been fortunate enough to see some of their presentations and some of their documents, and they keep telling us they're very successful as a club. There have been some excellent games of bowling there. There have been competitions. There have been Surrey Club there. They're very proud of their existence and their tradition. So I was very surprised tonight to hear that suddenly the whole world is going to end based on one decision taken tonight. In what I call the Articles of Association, and I accept they're called different things depending on which organisation, there's no doubt at all this is a bowling club. It's called Southey Bowling Club. Bowling is its game. And also the Secretary and others have said the bowling takes place during the day. Yet we're talking about a licence. And nobody was saying that they didn't want a licence. And the applicants themselves have not talked about their licence during the day when they play bowling. And that's because they know they have an issue with having a licence in this clubhouse when bowling doesn't take place, which isn't during the day. It's late into the evening. And so there's a certain guilt association with their presentation. And the application itself is nothing about bowling. And that's a real surprise to me because some residents did some research on when bowling clubs tend to lock up, when the last beer is sold, and when people are asked to leave. And it's nothing like the application here. In fact, if anybody is bowling and drinking after 10:30, it's a surprise. Even in Merton, which may have more open-minded attitudes to licensing, there's absolutely no doubt that no bowling club takes advantage of that. And that's because they are bowling clubs exactly like this one. I think one of the real challenges for residents is that when they moved here, the estate agents would have sold them this wonderful piece of greenery behind their house. And when they looked at the local development plan, it would have said that this had to be for recreation. Alcohol, I accept, has some degree of recreation, but the spirit of this presentation of this development framework was sport, bowling. Nothing to do with licensing and parties, and funerals were involved at all in the presentations and documents that I've seen. And all of a sudden, within 10 metres, around 30 households of differing ages and family sizes are going to have potentially a licence that goes way past midnight. And I have to say, I've not yet been to a pub or a club when people who potentially are very, very drunk are told at 12:30 at night to just be quiet as you leave. And I don't believe that regardless of the little information that's going to be given to them in terms of a leaflet or a placard, that people will say, you know, we must be quiet because there are 30 people that live very close to here. So I don't think that's fair on residents, as my fellow councillors have said, to be awoken way past midnight as people leave when they're meant to be there for bowling, as the Articles of Association. Now, we're looking at not just a membership licence, and excuse the lack of terminology here, or correct terminology. It could have been easy just to say that we're closing one property and we're opening another one, and I don't think anybody would be sitting here. But the fact is that they've asked for a bigger capacity. They've got 2 floors instead of 1. They've moved next to residents rather than far away from residents. And they've ceased to be concerned with the matter of bowling, for which the club for 133 years has been most successful. And frankly, if I was running a business for 133 years in an area I was successful in, I wouldn't want to give that up and do something that clearly I have no skills in at all. Because what we've seen last week, and I accept we only have one fact, and that's last week, there was a clear breach, which I now understand, I've been told, and maybe somebody can put me right, is criminal. It's a criminal offence to continue after the licence, yet that happened. And when I asked the questions, I was not given straight answers, but it seems to me that the very person asking for this licence was there on the evening. They were there on the evening in control of that premises 1 week before they were going to tell us that they could control a premises much bigger for much longer for a varied and large degree, different types of parties and funerals and presentations. Now that's a fact. You've got the fact because you heard the information from the applicant's presentation. They used the word metadata, which I don't quite see the connection, but it was after the licence should have been finished. But we are expected to believe that even though that criminal activity took place, that was last week and the future will not happen. So there's little doubt in the residents' minds that the bowling club is a part of the community, that a clubhouse is very necessary, and bowling and social activities is what they want to carry on for the next 133 years. But there's also no doubt at all in the mind of residents and councillors that to extend the licence, to allow music, to allow operators who clearly have a criminal breach in the last week alone to try and control something which clearly no one in that club can control. So if this is the end of this club's existence, I think this just shows how poorly managed they are. I believe that they should have the licensing that fits the last property, or you just reject this out of hand. And members of the committee, I thank you very much indeed for listening.
Any other interested party like to make a presentation?
I would just like to add to what's been said about control, and I'm sure the club is unaware, but if you go to the Stargazer Disco website, Facebook page, which I believe do a lot of work for this club, they say, come on down, party at Southey tonight. So they may be totally unaware that this is happening, but it's happening. Outside parties are being solicited to come to a party at Southey Bowling Club. So, and that's all I wanted to add. Thank you.
Sorry, sir, what was your name?
Edward, I beg your pardon, Edward Ash.
No problem, thank you.
Thank you.
I'm Stephanie Naylan. I live on Kingston Roads. Fortunately, the councillors have said most of what I wanted to say. I'm here mainly to put a face of somebody who backs onto it. As Councillor Dean mentioned, the bowling club has been there since the 1950s, and it's something that attracted both myself and most of our neighbours to the property. We used to look out, it was beautiful, it was green, it was open, there was trees and birds, and now we have a very large 2-storey clubhouse in our back garden. I'd just like to point out that while there has been no reports from environmental health, it's in a new venue, and so there's going to be potentially reports that might come in over the next couple of, whenever it starts opening. And I'd also just like to reiterate that it's a daytime sport, and we're not opposed to a license that mimics one that preceded it, but we do struggle to see why an extended one would be necessary. Thank you.
Would you like to question any of the interested parties?
No, thank you very much indeed.
Okay. Do you have any questions for the interested parties? No. Okay. I'd like to ask the licensing officer for any comments, clarifications.
I don't think that I have anything to add that hasn't been mentioned. I mean, obviously the club certificate will cover what is going to be used by the members only. It can't be used for the sale by retail of alcohol. They would maybe need a temporary event notice or something for that instead, but the club certificate can only be used for members, as has been stated by many people already.
The interested parties have made what I'm guessing is their closing statements. We will now ask the applicant for, if you have a closing statement.
Sorry, Chair, I don't know if this point is in order, but just the point that's been made about the Stargazers disco advertising on Facebook for discos at the Southey Bowling Club. I mean, I've just looked on Facebook, and indeed they are, and I just wondered whether that might be something the applicants could comment on.
I would like to hear, yes.
The only difficulty is that the rules of procedure mean that we aren't ambushed with information like this. As I understand it, someone has put that up. It's not done with our permission, and they've been asked to take it down. But it's completely irrelevant. There are no externally promoted events at these premises. If there were, you would know about it. No.
Clearly this is not an ambush because they did know about it, because they've just mentioned it, but they didn't mention it before. When did this information become apparent to you?
When I heard it mentioned by one of the residents just now, and I hastily took instructions.
When were they asked to take it down?
I am going to ask. I've been pretty generous, I think, with lots of matters that aren't really anything to do with today's hearing being thrown at me and at my client, and I am going to ask if we can draw the line now.
I need to say anything more. I mean, obviously, you've all been explaining your interests, your parts, your things you want to say in either way. It's for the committee to deliberate on when they come to deliberate, and it may be that it's dealt with in summaries from the residents as well as the applicant in due course.
I would also like to highlight that I appreciate the procedural side of things, but this is a hearing and residents clearly have concerns, so sometimes it would probably be best to answer the questions and alleviate any concerns.
I think we have done that. I mean, I have engaged to the greatest possible extent. I've answered the point that's just been raised now about something on a website that we don't control. I've said we've asked them to take it down, and I have said repeatedly in response to questions about external parties, non-members, we don't do that and we can't do that.
We'll now move on to any summary presentations for the interested parties, if you'd like to summarise based on what has been gone forth.
Thank you. Incredibly short, really. This is a new property in a different place. It's got much more potential to cause disruption for residents. We've examined the capacity of the organisation to control the events. We feel the panel may find that slightly lacking. We don't want to stop the club operating. We just feel that the proposal for a club certificate go too far. And we don't have anything further to add, really. It's, we would welcome the engagement that Mr. McGrath talked about of use during the day, but as we heard, there are no actual firm plans for that. But we'd encourage him to think on that more fully, because tonight we think that we've shown that the plans are lacking and they shouldn't be allowed to extend the hours for the disruption that they will cause to people's lives in a quiet family area. Thank you.
Councillor Dean.
Just like to add, I think residents have been incredibly patient over the years and have accepted things outside the current membership certificate. And if Southey Bowling Club had come tonight with saying we are moving our plot and we wish to have the same, that would have been acceptable. But based on new knowledge tonight, I actually think that that's even a struggle, and I'd like to see that reduced, but maybe a compromise on their behalf is they go back to the hours that they currently have. But I think residents would be happy if it was reduced.
Any other residents like to make a closing statement?
I just think what was demonstrated by the fact that Southey Bowling Club and its representatives aren't aware of what's happening. They're not fully in control of things, perhaps. And I question the legal advisor's ability to take instructions properly. He is a solicitor. So perhaps they probably need to get themselves back together and understand properly the effect of this application and really start controlling their business properly, because it doesn't look like they know what they're doing.
Okay, now we'll move on to your closing statement, Mr. Butt.
I think it's really important we take a step back and just appreciate what my client is and what my client wants to do. We are a bowling club situated in a residential area who have been there for a very long time. All of our members are locals. We don't make a profit. We can't make a profit. We exist by virtue of the facilities we have and the events we put on for the benefit of our members. And there have been at times some pretty hard words used that perhaps on reflection people will regret. Talking about bad faith, for example, is not an accusation that should be thrown around willy-nilly. We entirely respect and understand the concerns of local residents. A lot of this is really born out of a planning process that did become acrimonious, not really between the bowling club, between the developers and the local residents, and we are now at the hangover end of that. I am very grateful to everyone who has ultimately, when pushed, said, we don't want to see this application refused. We don't want the club to be put out of existence. But there is then a tension between saying, well, of course no one wants to see the club not exist anymore, and then saying we'll refuse the application, or saying cut back the hours, because without doubt, there is no point in the premises existing if they don't have a certificate that enables them to have social functions and bowling functions for members. And this bowling club, just like every other, pretty much, bowling club up and down the country, doesn't just have bowling events. It has bowling events for members, and the members are also then able to participate in social events. If the club closes, what's going to happen to the building on site? Derelict, that is not going to help in relation to crime and disorder. Bought up by a developer, an application for a premises license. In actual fact, what we currently have, a not-for-profit organisation run by locals for locals, is pretty much as good as anyone's going to get. And that's why ultimately nobody has really said they want to see the club close. But there is a danger in making points about bad faith and asking for hours to be reduced, that in the heat of battle in applications such as this, you really lose sight of what's important. The hours we're asking for are completely in line with the Council's statement of licensing policy. They are well within the framework hours for alcohol and for regulated entertainment. They are for a premises that, unlike the old premises, have been soundproofed. They are for a premises that, unlike the old premises, are going to have a noise-limiting device fitted to it. They are for a premises that, unlike the old premises, are going to have all of the planning conditions dealing with noise and all of the licensing conditions dealing with both noise and people outside the premises and doors and windows being shut. In fact, the reality is, if this application is granted with what is, on any view, a modest extension in hours, and I'm not talking about hours we've made up, they're significantly within the Council's statement of licensing policy. The residents, in fact, are going to be in a better position, a premises more able to control the noise, with conditions that will guarantee that. All that we're asking for is an extra hour for alcohol on a Friday and a Saturday, and an extra half hour for entertainment on a Friday and on a Saturday. We have given you assurances. We have offered conditions. Despite some of the heavy accusations that are made, there is absolutely no evidence whatsoever of any enforcement action being taken against these premises. We have never had any problems with environmental health. We have never had any problems with the police. We are a well-run premises. It is in the nature of club premises that they are policed by the members, run by the committee. That's why you don't have a DPS or SIA security guards. Whatever happens, there needs to be a better relationship going forward, and I have no doubt there will be. The planning application has been long and difficult for everyone. That can now be put behind everyone. If there are any problems at these premises, and there's no evidence of any real problems before, then of course the matter can be brought back before committee and the certificate can be reviewed. We have cut back the hours to the absolute minimum that we think can give these premises a good chance of a future, to offer events to members, and also to trade in order to allow the club to continue. The increase in hours is a very modest one indeed. It's significantly less than the application we've currently made it for. What we've tried to do is to present you with our realistic bottom line rather than trying to put hours and seek a compromise. I hope the committee feel that it has all of the relevant information. Councillor McLean, the chair, has seen the premises, and you will have seen for yourself how the old site and the new site are really comparable in terms of their location and their proximity to residential property, though of course I accept that an effect of this is, whereas before it was at one end, it is now at the other end, and change like that is always going to raise concerns. But I hope that everyone is, if not completely happy, then to an extent reassured by what they've heard today. I can hand up to your legal advisor just my proposed wording of the 5 conditions. Of course, it's a matter for the committee as to exactly how they word them, and Merton might have. I couldn't find any pool of standard conditions. Thank you very much for your time.
Okay, at this stage, this subcommittee are retiring to closed session and invite the legal advisor and clerk to join them to provide advice. If any members of the public are filming, could they please ensure their cameras are now switched off until the subcommittee return to the public session? Thank you. And I'd invite the legal officer to present the advice provided during the private session.
I didn't really give any legal advice. I think the committee was well aware of Thwaites and you know, the process of making a decision and that sort of thing. So I didn't really give legal advice as such.
Okay. Well, first of all, the committee would like to acknowledge and that they're very supportive of the bowling club, and also acknowledge its contribution as a community asset. In making our decision, we have considered and placed weight on the increased capacity. The present situation with the old side had a capacity of 20 to 30 per night, but with the potential to increase to over 100. With the new site, there is an increase to a potential 160. Therefore, we believe that we would like to see how that increased capacity will be managed going forward. As such, the committee's decision is to grant the certificate in line with the existing hours of operation, subject to the following conditions, which I'll now hand over to Mr. Bishop to outline.
This will, of course, come in a fully written and more detailed note or decision notice. So I'm giving you the bare bones at this stage. So effectively, indoor sporting events and recorded music will be 5 o'clock until 11 p.m. Monday to Friday, 10 to 11 p.m. Saturday, 12 to 11 p.m. 12 to 22 to 30 Sunday. Live music will be 7 to 2300 Fridays and Saturdays. Anything similar will be 11 to 9 Monday to Friday, 10 to 9 Saturday, and 12 to 8 on Sunday. Alcohol will be 5 to 2300 Monday to Friday, 11 to 2300 Saturday, 12 to 22:30 Sunday. The hours, overall hours, will be 11 to 11 p.m. Monday to Friday, 10 to 11 p.m. Saturday, 12 to 22:30 Sunday. In terms of Christmas Eve, the President's Day, Club Presentation Day, Christmas Day and New Year's Day, that will be midnight. In terms of New Year's Eve, that will be 1 a.m. In terms of the conditions, the following conditions will be imposed on the premises, on the certificate. One, a noise limiting device. Obviously, I'll give more that will be more detailed explanation of what that means in the decision letter. Outside, all use will stop at 11 p.m. Balconies will close to use by 9 p.m. No drinks outside after 10 p.m. even for smokers. All use, including regulated entertainment, will have blinds to be drawn after 9 p.m. and it's on both the first and ground floor. Smokers no more than 6 outside after 9 p.m. Signage to be erected to those leaving to remind them to be quiet and respect neighbours. Phone numbers to be provided to residents in case of nuisance directly, that go directly to the secretary and the committee members responsible. Dispersal policy management plan to be provided and agreed with the environmental health officer. Doors and windows to be closed except for access egress after 9 p.m. or for regulated entertainment events. The usual CCTV conditions. 2 committee members to be on duty managing the premises when a regulated entertainment event is occurring. Those are the conditions.
Can I just ask for clarity, because the intention was to reflect the existing licence. I think that you said from 5 until 11. The existing licence is from 10.
In terms of what? Indoor sporting events?
I think you said for everything. For alcohol, I think you said from 5 until...
No, for alcohol. Oh, for alcohol, the application had from 5 p.m. to 11 p.m. Mondays to Fridays. Yeah.
So the hours are being very significantly reduced, is the effect, but that's what's being granted.
Well, sorry, that's what the application involves.
Yes, but the committee have said that they're going to grant in line with the existing hours, although it sounds as if the existing hours but cut back.
I mean, difficulty we have is that you've applied for 5 o'clock to 11 p.m. on the application. We can't go outside that.
That's 1700.
Yeah, so they put in a minute to be 10 o'clock, so they're mistaken.
Does that say 1700? I can't read that. Is it
1200?
I think it says 1200. Just looking, because Saturday is clearly an 11 and Sunday is clearly a 12. I'm pretty sure that's a 12, not a...
Can I have a copy? Look at it. So in terms of page 23...
If you look at Saturday, it commences, that's clearly 11.
Yeah, it
Sunday
is.
is
I'm not saying Saturday's 5.
I think it's a 12, not a...
Sorry, let's go through that. So in terms of Monday, it says 1700.
I believe that's a 2, not a 7.
Well, if you look at Tuesday, Wednesday, Thursday and Friday, that says 5.
Well, that's what's being granted, all right. Right.
Why would Monday be different to those days if they're all the 1700?
Obviously, the applicant didn't have legal advice when he filled this in.
I understand that, but the problem we've got,
yes,
whether I want to, whether the committee wants to or not, is that we're bound by what the application says in terms of alcohol.
There can be a degree of common sense as well. I mean, I don't think there's any statutory restriction on...
We can't increase what you've applied for.
Right.
It would have to be a new application or...
And in terms of when the public or when members are on the premises when they are open, that must be until half an hour afterwards, because when the licence was converted, of course, members being on the premises is not an activity, so that wouldn't have been addressed in the licence. So if you're giving the premises what they have, then it should be the terminal hour of 2300 and premises open to the public half an hour after the last supply.
So if you go to the existing licence, sorry, I'm just trying to find the page.
It's at page 46.
Yep. So page 46, it doesn't have hours.
And that's because it's not a licensable activity. So because it was simply converted under the old system, nothing was put in. But given...
Does it not say, originally it says the terminal hours, and then it says for subject to the club rules for the opening hours?
No, the problem with page 46 is that it only has alcohol and it doesn't provide the hours of opening.
But I think that's because that's not a licensable activity. The forms have... That's definitely...
But the point here is that this would have been grandfathered.
Absolutely.
So that's why it probably wouldn't have put the hours in.
But it's a restriction. So if it's grandfathered, in fact, absent a restriction on the certificate as to when members must leave, there is no restriction. The standard interpretation is always to add half an hour. It would be a significant restriction if it were to be the last supply.
There's no extra half hour on... okay, you're saying in relation to grandfathered rights.
Yeah. The effect of that is, in effect, I'm not asking you to grandfather... Sorry.
No,
what was grandfather was a licence with no restriction. Now, I'm not going to frustrate what the committee are trying to do by asking you to do that. However, to give the applicant what could reasonably be expected to be the existing
I think the committee's decision is that it's 11 o'clock for closing everything.
But that is not what we currently
That's
have.
up to them.
If that exact point hasn't been considered, could I just ask that the committee briefly consider that? Because that would have the effect of significantly reducing the hours, because every other premises would normally have 20 minutes or half an hour at the conclusion of the supply or the sale of alcohol. And if the intention was to give us what
I'm
we had
happy for the
before-
committee to go out and reconsider that point, if you want me to. That's fine. I don't mind.
It wasn't specifically addressed at the hearing.
Yeah.
And if the intention was to give us what we had before...
I mean, again, the problem is that if we go back to the application...
Well, the application has the appropriate
does have an
hour.
extra
It
half
has a
hour, I
later
can see
hour.
that. I can
so
see
it's
that.
well within
But I
the
mean, again,
application.
it's down to what the committee are considering in terms of management and so on. But I'll let them have a think about it. Give us a few moments.
It might assist in resolving this without the need for it to be...
Let's see if we can have a chat.
Thank you.
Can I just draw your attention to the planning committee hours of use, which I know aren't strictly relevant, but I'm assuming that's what they applied for, which is the hours shall operate only between the hours of 1100 and 2300.
Yeah, we're not considering.
No, I know, but I'm
planning.
just saying that's what the current use
I'm
that
well,
they
I'm
asked
well,
for
we're
is.
well aware, sorry, the committee's well aware of the hours
Fine,
for the
okay.
planning, but this is an application based on
Indeed.
public nuisance and crime and disorder and things like that. But just going to have a quick chat.
The committee has reached a decision. All licensable activities will end at 11 o'clock. All members and guests are to be off-site by 11:30, no later. That will be the same for the special event night, half an hour off-site. Correct. Yes. So, yeah.
22:30 stops.
11 o'clock off-site. Correct. Notice of this decision will be sent out to all parties within 5 days. On that note, the hearing is closed.